I have two legal documents to talk about today. The first one is in the Wallace v. LVMPD case. It's just a judge's order. Let's read it. To date, the parties have not filed a stipulated discovery plan as required by Local Rule 26-1A. To the extent defendants seek to stay discovery pending resolution of their motions to dismiss, they must file a motion addressing the pertinent standards by September 12, 2023. And there's a citation. If a motion to stay discovery is filed by that date, discovery will be stayed on an interim basis pending resolution of that request. If a motion to stay discovery is not filed by that date, the parties must file a joint discovery plan by September 19, 2023. Now, I suspect from the defence's point of view, it's probably easier to file a motion to stay the proceedings than to try and get a joint discovery plan with Floyd Wallace, because he's likely to say, what? Right, on to the next one, which is in the Springer v. the 7th Judicial District Court, Mercedes Murphy, Shannon Murdoch Poff, Jason Jones and Susan Rossignol. Now, as we know, the defendants entered the case, and this is their response to plaintiff's complaint for declaratory judgment and injunctive relief for civil rights violations under the 42 USCA violations of rights protected by the New Mexico Civil Rights Act, emergency request for a temporary restraining order, request for a preliminary injunction, permanent injunctive relief and damages. Comes now defendants 7th Judicial District Court, Mercedes Murphy, Shannon Murdoch Poff, Jason Jones and Susan Rossignol, collectively hereinafter defendants, by and through their counsel of record, Garcia Law Group, LLC, and hereby submit their response to plaintiff's complaint for declaratory judgment and injunctive relief for civil rights violations under 42 USCA violations of rights protected by the New Mexico Civil Rights Act, emergency request for a temporary restraining order, request for preliminary injunction, permanent injunctive relief and damages, hereinafter complaint. Introduction. James Springer, hereinafter plaintiff, seeks an injunction barring defendants from limiting plaintiff's presence in the 7th Judicial District Courthouse to his own matters or specific court business and with a law enforcement escort. Plaintiff's entire case is based on the premise that defendants are violating his First Amendment and due process rights. Plaintiff argues from a faulty premise. First, plaintiff does not meet the legal requirements for an injunction. Second, the restrictions on plaintiff's access to the court are content neutral and reasonable in light of the disruption his refusal to follow court rules has caused to official court business. Finally, plaintiff's acts 10 of spoliation have negatively impacted defendant's ability to respond to his complaint. Defendants reserves argument concerning immunity and the Pullman doctrine for future motions practice. Defendant respectfully requests that this court deny plaintiff's complaint. Factual background. On or about January 27, 2023, plaintiff entered a courtroom at the 7th Judicial District Court to observe a hearing before hearing officer Gordon Bennett, hereinafter H.O. Bennett. See Freeman, Sheriff and Deputies Stand Up Against Bad New Mexico Judiciary, Gordon Bennett, YouTube, February 20, 2023, which is attached hereto as Exhibit A. During this time, the state of New Mexico had a mask mandate in effect for its courtrooms. However, when H.O. Bennett asked plaintiff to put on a mask, plaintiff refused. H.O. Bennett went off the record and left the courtroom to ask for assistance from law enforcement. Upon H.O. Bennett's return to the courtroom, he asked plaintiff to identify himself. Below is an excerpt of their conversation. H.O. Bennett: what's your name? Plaintiff: I didn't give it, I'm sorry. H.O. Bennett, inaudible. Plaintiff: just trying to spectate a public hearing, nothing more, nothing less. H.O. Bennett: I can appreciate that you're here to spectate, and I can appreciate that this is a public hearing, but you're not going to violate the rules. Plaintiff: which rules are those? H.O. Bennett: put a mask on. Plaintiff: oh, you want me to put a mask on? Tell you what, if you threaten me with arrest, I'll just leave. H.O. Bennett: I'm not threatening anything. I'm just telling you that if you do not abide by the rules of the courtroom, you will leave. If you choose not to leave of your own accord, you will be escorted. Plaintiff: Would I be arrested or charged with anything? H.O. Bennett: Well, if you continue this, I may charge you with contempt. Plaintiff: Okay, so there's a threat of arrest then, if I don't do what you say right now. H.O. Bennett: Would you happen to have your phone out now recording this? Plaintiff: I mean, if there's a threat of arrest, I'll just leave. H.O. Bennett: Are you recording this conversation? Plaintiff: The court is. There's a camera there. H.O. Bennett: You're right. The court is. By statute and rule, I am allowed. I am required to record. Well, by statute. Plaintiff: Tell you what, son. I'll just get a bigger team when we come back, sweetheart. All right, we'll be back. See also James Freeman caught in a bull-faced lie by his camera in his own courtroom. Dishonourable Gordon Bennett. YouTube, February 16, 2023, which is attached here too as Exhibit B. Sometime thereafter, plaintiff asked the Torrance County Sheriff's Office, hereinafter TCSO, whether they would be enforcing the mask mandate. The sheriff stated, We're not going to enforce a mask mandate in the courtroom or anywhere else, okay? Court staff were harassed and threatened after this incident. On February 28, 2023, the 7th Judicial Court entered an administrative order, hereinafter order, in the interest of the safety and security of its judges, special commissioners, hearing officers, and other court personnel. See generally administrative order entered February 28, 2023, a copy of which is attached to plaintiff's complaint as Exhibit 1 and is incorporated herein by reference. The order further explains that plaintiff is an obstinate visitor, is banned from the Torrance County District Court unless appearing for a hearing or having specific court business, and must be escorted by the Torrance County Sheriff's Office while in the building. When plaintiff sought to harass court staff at the courthouses in the 7th Judicial District, the court amended the order to include the courthouses in Torrance County, Catron County, Sirocco County, and Sierra County. I'll probably get corrected on the pronunciation of one of those. See generally, amended administrative order entered March 23, 2023, a copy of which is attached to plaintiff's complaint at Exhibit 3, and is incorporated herein by reference. Plaintiff refused again to comply with court orders. When a Torrance County Court clerk asked plaintiff where his law enforcement was during one of his visits, plaintiff responded with hostility. Clerk: Where is your escort? Plaintiff: My escort? Clerk: Yes, by court order you are required to be escorted by law enforcement. Plaintiff: An escort? Clerk: Yes, sir. Plaintiff: I don't know if you're aware, but prostitution is illegal in New Mexico. I don't know if you're trying to solicit me right now, but I don't appreciate it. As a matter of fact, I think I'll head over to the Sheriff's Department right now and let them know that you're trying to solicit me. Is that what you're doing? Are you trying to be my escort? See James Freeman, court clerk tries to force an escort on me, YouTube, May 28, 2023, which is attached here too at Exhibit C. Due to plaintiff's continued refusal to follow court orders, the 7th Judicial District Court sent plaintiff a notice of order to show cause hearing, filed June 7, 2023. On June 9, 2023, plaintiff filed his complaint for declaratory judgment and injunctive relief for civil rights violations under 42 U.S.C.A. violations of rights protected by the New Mexico Civil Rights Act, emergency request for a temporary restraining order, request for preliminary injunction, permanent injunctive relief and damages, hereinafter complaint. Defendants 7th Judicial Court, Mercedes Murphy, hereinafter Judge Murphy, and Shannon Murdoch-Poff, hereinafter Judge Murdoch-Poff, recuse themselves from the state court proceedings, and this matter is pending in the 13th Judicial District Court. On August 29, 2023, Counsel for Defendants served Plaintiff's Counsel a preservation letter asking plaintiff to preserve all evidence related to this matter. A copy of the preservation letter is attached hereto as Exhibit D. The following day, plaintiff admitted that he deleted some evidence. They also sent something to my attorneys saying that they want me to preserve all of my journalistic materials for them so they can come and take those materials from me. They've said that they need me to preserve all my journalist materials because they intend to come and try to bully me and take those journalist materials from me, including any private conversations that I've had with confidential informants, because they know that there are people, not just within their police department and their legislature, but within the judicial system in New Mexico that are giving me information. They know it. It doesn't matter because I delete it all as soon as it's read, but they know, and they're trying to bully anyone who would be giving me information. See James Freeman. I'm suing the courts for rights violations, but they just gave me the deal offer of a lifetime. YouTube, August 30, 2023. Which is attached hereto as Exhibit E. Standard of review. Because a preliminary injunction is an extraordinary remedy, the right to relief must be clear and unequivocal. As such, the party requesting a preliminary injunction under Federal Rule Civil Procedure 65 must establish 1. He will suffer irreparable injury unless the injunction issues. 2. The threatened injury outweighs whatever damages the proposed injunction may cause the opposing party. 3. The injunction, if issued, would not be adverse to the public interest. And 4. There is a substantial likelihood of success on the merits. The citation. In relation to the case at hand, it is clear that none of these factors are met. Legal argument. 1. Plaintiff's petition as a matter of law fails to meet the necessary requirements of a preliminary injunction. A. Plaintiff's claim provides no suggestion that plaintiffs will suffer irreparable injury unless the injunction is granted. The party seeking injunctive relief must show that the injury complained of is of such imminence that there is a clear and present need for equitable relief to prevent irreparable harm. Citation. Preliminary injunction relief does not remedy past harm, but protects plaintiffs from irreparable injury that will surely result without the injunction. Citation. Plaintiff has not identified the irreparable harm he faces. Instead, he points broadly to the First Amendment as if alleging constitutional violations is sufficient grounds for an injunction. In fact, an injunction is not a matter of right, but it may be granted only in sound discretion of court when remedy at law is not adequate. And the citation. Here, plaintiff exhibits no concern for the disruption his refusal to follow court rules and orders has caused. Further, the court's definition of irreparable injury clearly does not coincide with the facts of this case. In fact, plaintiff's position lacks in its entirety any claim suggesting that an irreparable harm has occurred or is likely to occur. B. Plaintiff's claims provide no suggestion the threatened injury outweighs any damage the injunction may cause the defendants. Allowing the plaintiff to disregard court rules and disrupt court proceedings will create much more harm to the defendants than to the plaintiff. Indeed, plaintiff has made it clear that he will not follow court rules. See generally Exhibits A, B, C and E. Further, defendants face the complicity of the Torrance County Sheriff's Office and Estancia Police Department in their refusal to enforce court rules and orders as it pertains to plaintiff. Without a means to enforce the court rules and order, and given plaintiff's disruption, defendants would be highly prejudiced if plaintiff's injunctions were granted. Further, such an injunction would permit plaintiff to harass court staff and disrupt court business with impunity. C. Issuance of the injunction will be adverse to the public interest. It is widely accepted that an individual has the right to bring a lawsuit against an opposing party who he believes has done him wrong. If the court grants an injunction in this matter, it will improperly suggest that every individual with a cell phone and or camera who cannot bring it into the courthouse has automatically suffered irreparable injury. Such a standard would obviously be adverse to the public's interest and severely hinder the court's ability to administer justice. The effect of federal court intervention in state courthouse conduct would be to impose administrative oversight burdens on state courts and severely curtail the state's courts' ability to ensure the safety and well-being of its staff and the public visiting the courthouse. D. Plaintiff's claim failed to provide a substantial likelihood that plaintiff will prevail on the merits. The facts of this case clearly do not justify the issuance of a restraining order. Plaintiff has contemptuously disregarded the court rules and orders, harassed court staff and disrupted court business. Further, plaintiff has deleted evidence relevant to this matter. It is evident that plaintiff has little to no regard for the judicial system, whether it be other cases or his own. As such, the issuance of a restraining order would be a waste of judicial resources and does not warrant an injunction for plaintiff. 2. Restriction of access was reasonable. A. Plaintiff refused and continues to refuse to comply with court rules of conduct. Plaintiff contends that defendant's order is unconstitutional because it impermissibly abridges the First Amendment. However, plaintiff fails to appreciate that while court hearings are open to the public, the court has rules. Specifically, the New Mexico court has promulgated the following rules as relevant to this matter. Video or audio recording devices. No photographic or audio-visual equipment of any type, including cameras, video or audio recorders or players, are allowed without prior court approval. Cell phones. No person other than members of the judiciary, attorneys, peace officers and court staff shall be allowed to carry a cell phone into the courtroom. All cell phones must be turned off before entering a courtroom. Any cell phone that rings or makes any audible sounds in a courtroom may be confiscated and held by security, a bailiff, or any member of the district judge's staff. The cell phone will be returned upon payment of $25 to the district court clerk. A district judge may impose additional sanctions for repeated offences by the same person, including but not limited to increasingly severe monetary penalties. Disruptive behaviour. Disruptive behaviour will not be tolerated. Security staff may remove offenders from the building and judges may hold violators in contempt of court. And there's a citation. In addition to the rules for courtroom conduct listed above, during the January 27, 2023 incident, the state of New Mexico had a mask mandate for its courtrooms in force. Citation. This mandate remained in force until March 31, 2023. Citation. Nonetheless, plaintiff refused to comply with the court rules or the mask mandate. Plaintiff did not get court approval for a video or audio recording. Plaintiff brought a cell phone into the courtroom and did not turn it off. Plaintiff was disruptive during a court proceeding. Plaintiff did not wear a mask into the courtroom and when asked to do so, refused. See generally Exhibits A, B, C and E. Even after leaving the courtroom on January 27, 2023, plaintiff sought to return to the 7th Judicial District Courts without following any of the above stated rules and documented his non-compliance on his YouTube channel. In light of such persistent disregard for court conduct, defendant's order was reasonable restriction to ensure the safety of court staff as well as the administration of justice. B. The courthouse is not a traditional public forum. In examining restrictions on these government institutions, the Supreme Court has held that the government may exclude peaceful assembly or access which interferes with the function of the institution. Citation. In examining such restriction, the Supreme Court has used an analysis based on the place in question. Is it a traditional public forum? Under this lens, the Supreme Court found that restriction of access was reasonable for the jail and military base and the letterboxes because they were not public forums. The fact that the public is generally allowed access does not transform a place owned or operated by the government into a public forum. The test here is not whether the courthouse is appropriate for video recordings, but whether the character of the place is appropriate for the expression of views and ideas generally. The jail grounds in Adelaide may have been an appropriate place to assemble to protest the arrest of students, racial segregation and segregation at the jail. but that did not make it a public forum. Conversely, streets and parks are traditional public forums. Citation. The 7th Judicial District Courthouse is more similar to the jail considered in Adderley, the military base considered in Greer, and the letterboxes considered in Greenborough. In examining restrictions on these government institutions, the Supreme Court has held that the government may exclude peaceful assembly or access which interferes with the function of the institution. In this context, the restriction need only be reasonable and content neutral. Citations. Adderley held that government may, in non-public forum situations, reasonably limit access to government places. Citation. The United States Constitution does not forbid a state to control the use of its own property for its own lawful, non-discriminatory purpose. Here, the 7th Judicial District Court's restriction, an order in limiting plaintiff's cases to the courthouse for his own hearings or official court business, and with a law enforcement escort, is reasonable. The state, no less than a private owner of property, has power to preserve the property under its control for the use to which it is lawfully dedicated. The restriction is content neutral, as its purpose is to ensure the compliance with rules for court conduct. Even now, plaintiff refuses to follow court rules of conduct. See Exhibit E. Further, in imposing the restrictions, the 7th Judicial District was ensuring the safety of its court staff who have been needlessly harassed. The Torrance County District Court had to go on lockdown due to threats to its staff. Defendants were and are protecting its courtroom's staff and litigants. Nonetheless, plaintiff makes light of the seriousness of his conduct and persists in his harassment. Accordingly, the restrictions on plaintiff are reasonable. C. Plaintiff is not a member of the press, and even if he were, the First Amendment does not grant him special right of access to gather information above and beyond that of the public. I'd be interested to hear Merb's view on not a member of the press. That's an interesting one. I'm not sure I even agree with that. Well, I'm not sure that I do agree with that, because everyone is a member of the press. There is a difference between a member of the press and a member of an official press body. But in terms of the First Amendment, everyone is a member of the press. But hey-ho, that's as I understand it. Plaintiff asserts that he is a member of the press and therefore the order offends the First Amendment. He argues that his right to gather news was impermissibly abridged. Defendants note that plaintiff has not held himself as a member of the press to court staff, nor follow the procedures promulgated by the New Mexico courts for the press. Notably, at the January 27, 2023 hearing, plaintiff snuck in his cell phone to video record without court approval and refused to identify himself when asked by an officer of the court. Now that, I think, I'm agreeing there. He isn't operating as an official member of the press would operate. But is that a First Amendment issue? There can be no doubt that freedom of the press is extremely important and necessary in our democratic form of government. Freedom of the press necessarily involves two things: acquisition of information and dissemination of information. There's a citation. Freedom of the press is a very broad concept. Here is a narrow issue: the right of access by the press or public to an area controlled by the government for an indeterminate purpose. The Supreme Court has rejected the argument that the First Amendment requires that members of the press be given special access to areas controlled by government. The citation. Members of the press sought to strike down on First Amendment grounds a California Department of Corrections manual provision which provided that press and other media interviews with specific individual inmates will not be permitted. In holding that the First Amendment does not require that members of the press have a special right of access to gather information above and beyond that of the public generally, the court examined the governmental interest behind the regulation and the right of access allowed to the prison. The court noted that the regulation was not part of an attempt to conceal conditions in the prison or to frustrate the ability of the press to report those conditions. As above discussed, The defendant's restriction is aimed at protecting its operation staff and litigants, not at concealing the judicial system. 3. Plaintiff's spoliation. Plaintiff's spoliation of evidence maliciously impedes defendant's ability to defend and litigate this matter. While the duty to preserve evidence is often triggered by the filing of a lawsuit, this duty may arise if a party knows or should have known that the material may be relevant to future litigation. Citation. The obligation to preserve evidence arises when a party should have known. Citation. In determining whether a party's duty to preserve has been triggered, the courts evaluate facts such as the likelihood that a certain kind of incident will result in litigation. Ultimately, a party's duty to preserve arises when it has noticed that the documents might be relevant to a reasonably defined future litigation. The court's decision as to when a party was on notice must be guided by the particular facts of each case. Citation. Once it is established that a party's duty to preserve has been triggered, the inquiry into whether a party has honoured its obligation to preserve evidence turns on reasonableness, which must be considered in the context of whether what was done or not done was proportional to that case and consistent with clearly established applicable standards. And there's a citation. Here, plaintiff has sufficient notice of potential litigation because he is the party who initiated the lawsuit. Therefore, he should have ensured the maintenance of his raw videos, edited videos, notes and other potential evidence. Defendants' listed evidence plaintiff should preserve. However, plaintiff publicly admits to spoliation the day after his counsel is served a preservation letter. See Exhibit E. The near immediate timing of plaintiff's spoliation conduct demonstrates intentionality and further underscores plaintiff's blatant disregard for the judicial system. It is difficult for defendants to adequately gather information and defend this case when plaintiff engages in such egregious behaviour. Affirmative defences to complaint. First affirmative defence. None of the actions described in plaintiff's complaint constitute a violation of plaintiff's statutory rights by defendants. Second affirmative defence. Plaintiff has alleged a number of causes of action which fail to state a claim for which relief can be granted. Third affirmative defence. Defendants' actions in this case were objectively reasonable under the circumstances and did not violate any of plaintiff's clearly established constitutional rights, thereby entitling defendants to qualified immunity. Fourth affirmative defence. Defendants' actions in this case were in their capacity as judges, thereby entitling them to judicial immunity. Fifth affirmative defence. Defendants' actions in this case fall within the protection of the 11th Amendment. Sixth affirmative defence. This court lacks jurisdiction over this matter. Seventh affirmative defence. To the extent that any provision of the New Mexico Tort Claims Act is changed by operation of law, any such changes are not retroactively applicable hereto. Eighth affirmative defence. Claim against defendants are barred by the exclusive remedies available pursuant to the New Mexico Tort Claims Act. Ninth affirmative defence. To the extent applicable, plaintiffs' claims against defendants are barred, in whole or in part, by the doctrines of estoppel, laches, waiver, and or unclean hands. Tenth affirmative defence. Defendants are entitled to all protections, rights, benefits and damages caps conferred by the New Mexico Tort Claims Act. Citation. As set forth in the Act and case law construing same. Reservation of rights. The affirmative defences set forth herein are preliminary and pled without the benefit of all the facts underlying and pertaining to the plaintiff's claims. Defendants' affirmative defences may be withdrawn as a result of discovery in the case. Defendants reserve the right to amend their answer to plaintiff's complaint and to raise such further or additional defences or counterclaims as may be available upon facts to be developed in discovery and or applicable substantive law. Conclusion. Wherefore, defendants 7 Judicial District, Mercedes Murphy, Shannon Murdoch-Poff, Jason Jones and Suzanne Rossignol request that this court deny plaintiff's complaint for declaratory judgment and injunctive relief for civil rights violations under 42 U.S.C.A. violation of rights protected by New Mexico Civil Rights Act. Emergency request for a temporary restraining order, request for preliminary injunction, permanent injunctive relief and damages, award defendants their costs and fees associated with responding to plaintiff's complaint, and grant all other relief this court deems just and proper. Right, okay. I did download the attachments to the response, so let's have a look at these. So the first one is a letter to Springer's solicitors. Dear Mr. Dunn and Mr. Cook, please be advised that this firm has been retained to represent the 7th Judicial District, Judge Mercedes Murphy, Judge Shannon Murdoch-Poff, Jason Jones, and Susan Rosignol in the above referenced matter. This letter is a formal request that your client, James Springer, preserve and not alter the following evidence. Any and all raw, unedited and edited photos, video recordings, recorded audio or computer media, measurements, real evidence documents, materials and all other evidence and things relating to Mr. Springer's YouTube channels and social media accounts which are presently in his possession or the possession of his aliases, businesses, employees or agents. 2. Any and all posts, comments and messages by Mr. Springer's social media accounts platforms, including but not limited to his YouTube channels, Instagram, Facebook, TikTok, X (formerly Twitter), WhatsApp, Snapchat, Reddit, blogs and video blogs. 3. Any and all posts, comments and messages on Mr. Springer's social media accounts platforms, including but not limited to his YouTube channels, Instagram, Facebook, TikTok, X (formerly Twitter), WhatsApp, Snapchat, Reddit, blogs and video blogs. 4. Any and all notes, drafts, scripts and communications pertaining to Mr. Springer's social media accounts platforms, including but not limited to. I won't repeat them. 5. Any and all articles and interviews pertaining to Mr. Springer's social media accounts platforms, including but not limited to. I won't read them. 6. Any and all correspondence such as, but not limited to, emails, messages, texts and letters from and to followers of Mr. Springer's social media accounts platforms, including but not limited to. 7. Any and all reviews pertaining to Mr. Springer's and or his social media accounts platforms, including but not limited to his... I won't read them. 8. Any and all complaints pertaining to Mr. Springer and or his social media accounts platforms, including but not limited to. 9. Any and all investigations pertaining to Mr. Springer and or his social media accounts platforms, including but not limited to. 10. Documentation of any and all incidents that occurred as a result of the actions of Mr. Springer and or his social media accounts platforms, including but not limited to. 11. Any and all statements, notes, audio or video recordings and other material or things obtained from any person having information pertaining to Mr. Springer and or his social media accounts platforms, including but not limited to. 12. Any and all financial information pertaining to Mr. Springer and or his social media accounts, including but not limited to. Please retain evidence. Please also forward a copy of this letter to all persons and entities with custodial responsibility for the items referred to in this letter, specifically including third parties and vendors. And that's the letter. Okay, that's it. As I say, I'm interested in that definitive he's not a member of the press, because my view is that you're all members of the press, but there is a difference between being a member of the press and being a member of the official press who has applied to be official press at a courthouse. Thanks for watching.